entertained a request for pretrial diversion from Ms. Vandiver. I need to email her the application so she can begin that process. I don't think Mr. Strawn is opposed to resetting it so that we can do that.
That's correct.
I want to get in this. Can I see the docket sheet? We had this issue yesterday. She has not taken a drug test since back when she tested positive in December of last year.
I think she's actually, well, I don't know.
Zoom in January, Zoom in March, Zoom in April because she was ill.
I think she's anticipating it today, Judge.
She was
already
ill
mentioned
in
it to
May,
me.
so I'm gonna send her to take a drug test. Ma'am, you'll go take the test when you get done with it. You know the drill. Come back in the courtroom and we'll go over the results together. I do now. I just unmuted myself.
So are we waiting?
I don't know who is they. Oh.
Are we waiting for the reset until then, or?
And well, I'm just getting ready to reset
Oh,
it
okay.
July 8th
Thank
at
you, Judge.
1:30, unless y'all can get in sooner and want to
Yes.
present the contract to me.
We're gonna try to do that, Judge.
Okay.
You can put it in an envelope and drop that box. Judge Holly Goff.
Holly Goff.
Oh, yeah. Yes, she's left 2 messages with me. First one early after 11 a.m. this morning and one later before lunch. And her estimated time of arrival is 2:24 p.m. So I've got other court issues, other places I need to address. So
Here's what I'll do. I'll call it and I'm here until we're done. So if she shows up, I'll reconsider.
yes, sir. This is my city docket today.
I got
So
you.
I've got,
We can call you if we need to or text you.
yes, sir.
Holly Goff, cause number CR 20-0447-392, state of Texas versus Holly Goff. Is there a Holly Goff in the courtroom? I see no one. I hear no answer. There's not a Holly Goff appearing via Zoom. No answer in the lobby. The time is now 1:44. The docket was for 1:30. The court will entertain a motion.
State would request bond forfeiture.
I hear him.
Granted, capital issue shall be held with no bond. And again, if she shows up, we'll reconsider.
Thank you, Judge.
Paul Haber.
Daryl Mincy on page 1.
Mr. Menifee, come on up. These are cause number CR 20-0694 and 695-392, both styled the state of Texas versus Daryl Menifee, and both set for pretrial. Any pretrial from the state?
Yes, Your Honor. Standard motion for discussion.
No objection.
Granted. And on behalf of Mr. Menifee,
Your Honor, it was my understanding that this was reset for discovery status today because there was an outstanding 911 call. I did just receive that 911 call a couple days ago, and I would ask if needed to reserve the right to set for pretrial.
so I'll grant you leave if you discover something on the 911 call that require you to file any pretrial motion. So well, then the court will deem pretrial is held. And again, Ms. Fallhaber, if you've got something, let me know, or let Kevin know if you need a hearing, and I'll set this for status on July 8th at 1:30.
Thank you. And Your Honor, just for purposes of the record, I did convey Mr. Strong's bargain offer, which is for 10 years TBC, and it's
Okay.
been rejected by my client.
Okay, well, we still have status to go, so we'll see you in status, Mr. Menifee. So as soon as you receive your reset notice, sir, you can have a seat.
My knowledge, yeah. Robert Lima, also on take 1.
Robert Lima, come on up, sir. This is cause number CR 20-0552-392, state of Texas versus Robert Lima. And this is set for a status. However, before we go any further, I think there's a motion to recuse that I'm looking at here. Give me just a moment. So he's filed this, or he's requested you file a motion to recuse me because I prosecuted him.
Yes, Your Honor, in the case that I believe is Defense Exhibit B that's attached to the motion, it's my client's personal memory that you were sitting at counsel table in the trial and that he believes you did opening statement and also cross-examined him personally in the trial.
I don't recall, because it looks like this was a plea.
It ultimately wound up in a plea, but it was to a lesser included after the jury had been sworn and testimony began.
And that was in here, right?
That's what happened is you originally tried for a higher offense, and then after trial began, it was pled down to an included lesser.
I mean, technically, I mean, I haven't prosecuted on this case. I don't know anything about this case. Were there any enhancements that were pled or found to be true in that first trial?
I know there were enhancements that were alleged.
Or is this case alleged as an enhancement? Yeah, you do. All right, well, then the court will grant the motion to recuse because that case is an enhancement that must be proven true by the state in here. And so the court will recuse itself. It'll go to Judge Charles and he'll appoint another judge. I mean, if it wasn't for that, I would find no reason to recuse, but since it's used as an enhancement. All right, and I can't do anything else on the case because I've just recused myself. So wherever it ends up, they'll get a setting to you. You can have a seat, Mr. Lehman. Good luck to you. Sir.
That's all I have, maybe. Excuse me.
Yes, ma'am.
Thank you.
Yes, sir. You know what page it's on?
Near the end.
Yeah. That's right here. He starts. Matthews, is that what you said? You wanna do
Yes,
that first?
Matthews, McNair, and Matthews.
Marty Matthews, come on up, sir. This is cause number CR 20-0645-392, the state of Texas versus Marty Matthews, and that is set for status. Where are we at?
Judge, Mr. Strong and I exchanged a lot of messages. I think we're not too far apart. I think maybe if you gave us one more status, we might be able to work this out.
What's the offer now?
Right now, it's 12 years.
12 years to do? Are y'all still negotiating?
We are.
All right, then I'll reset status for July 8th at 1:30.
Thank you, Judge.
As soon as you receive that reset notice, Mr. Matthews, you can have a seat. But wait for the reset. All right, and then Mr. McNair, come on up.
Pretty much the same.
I mean, typically we don't give two statuses, but the pandemic has changed everything.
If the court wants to set the trial.
No, it's okay. CR 20-0319 and CR 20-0664-392. Both styled the state of Texas versus Matthew McNair. And is there an offer pending on this one?
There is 30 years on the man.
So 30 years to take care of both. And are y'all still in negotiations? All right, Mr. McNair, is it all right if I reset this to July 8th? All right, then I'm resetting it to July 8th at 1:30 for status.
Thank you, Judge.
And Mr. McNair, wait till you get your reset notice and you can have a seat. And Ms. Mooneyham, Ms. Mooneyham, come on up. And I see the docket sheet. This is cause number CR 20-0505-392, the state of Texas versus Amy Mooneyham. And that is set for status. Where y'all at?
Judge, we're still working on a resolution of this case as well, but I'm putting on the trial docket. If the court wants to put this on the trial docket.
Did we get a lab back? Okay. All right, what's the offer?
Offer in Ms. Mooneyham's case is 5 years to December.
Okay, and are y'all still negotiating? Or do I need to put it on the trial docket?
Right now, the defense is asking for probation. We're asking for trial document.
Okay, all right, well then the court deemed status is held. Ms. Mooneyham, you'll get a trial then. And we're gonna actually start moving pretty quick, so you may get a trial before you know it. And so I will tell you this, the last 2 trial dockets we had, they pled every case on there. Had I known you would have wanted a trial, I could have tried you last week? Yeah, and so it'll come up before you know it. Remember any conditions of bond you're on, and you'll receive a notice. You want to reset her now?
She's gonna be sitting around 45, so we'll let her work.
Okay, so Ms. Mooneyham, just stay in touch with your bondsman and your lawyer, and you'll receive a reset notice when we're ready to get you a trial. Yes, ma'am.
Thank you, Judge. My excuse.
Yes, sir. Good to see you.
Good to see you.
Mr. Schmidt.
Mary Bearden, page 5, and also, if you don't mind, John Bearden.
Mary Bearden and John Bearden. All right, these are cause numbers CR 20-0630 and 0631-392, both styled the state of Texas versus Mary Bearden. And then CR 20-0628 and 0629-392, both styled the state of Texas versus John Bearden. And all of these cases are set for status.
That's right, Judge. We are still negotiating. This is.
Thought y'all were close to back in.
We
I
are.
still think we're close. I think we are in reaching agreement. I don't think it's going to go to trial.
I agree with that. We really are negotiating in good faith. There's a lot that went into this case. The records are voluminous, and so we're very, very close.
How close is very, very close?
I'd say 30 days close.
30 days close. 30 days?
Do you agree?
Why don't we just keep that July 8th setting? But if we don't resolve by then, I'm putting y'all on the trial docket.
We understand, Judge. We should have
Okay.
it. We'll get it.
All
Absolutely.
right, well then, I'm going to reset all 4 of these cases for each of the co-defendants to July 8th at 1:30 for their last status.
Yes, sir. Yeah, he's not here.
Oh, there you go.
May they be excused?
Yes, sir.
That'd be-
Yes, sir.
Back in
Ms.
line.
Mellentree,
Oh, okay.
I'm doing well. How are you?
I'm trying to make the change.
Mr. Moore, come on up.
Yes, we've been busy over these Texas and Smith County. We having trials over there.
Well, we're fixing to. Well, we've had them scheduled, but they all pled out. So, but it's okay.
That's good. Judge,
Did they? I don't think Smith County ever shut down. Did they? Did they even know there was a pandemic going on over there?
ask Judge Russell.
This CR 20-0395-173, state of Texas versus Demetrius Moore, set for status.
I got my discovery on it. So can we have July the 8th? Because I'm gonna review it this weekend.
Sure, and he's got, actually, he was due to be in trial but we had an officer out and then
Okay.
my schedule, so he was close. All right, so I'll just reset this status to July the 8th.
Thank you, Your Honor.
You all right with that, Mr. Moore? You're the one on bond. Well, you have a choice.
Yes,
Okay,
sir. Say yes.
July 8th, 1:30. Listen to your turn.
Thank you.
I was appointed, I'm sorry, remember, if this is Demetrius Moore,
But you were on the other cases.
so is this a different case?
It's a different case.
Oh, well, then never mind. Disregard I even saying that. I was thinking that he had hired her
No,
represent
you don't. call
on
it.
my other case. I was gonna get off.
No, no mistake.
No, this is another case, Mr. Mills. He's got 3 attorneys. Okay, all right. We'll see you in July.
Oh, my God. Thank you.
Yes, ma'am. Mr. Weiner.
Yes, page 8, Robert Kopat.
Oh, my docket was 8.
I got it. All right, this is cause number CR 20-0713-392, the state of Texas versus Robert Hocutt, set for status.
Yes, Your Honor, we have 2 offers. I got a second offer from the state upon my request. I was asking for a second offer. And so what we'd like to do is set this for a plea and execute a waiver of jury trial today, so that my client can have, one of them involves, time on an ag charge, and the other one is a cap, wrecking a cap on an open plea. And so
Okay.
he needs some time to consider.
So this is in consideration for some kind of bargain.
Yeah,
Yes, sir. He's got an offer that we've made to him, a
Right.
straight up time offer, and he also has the option to plead open to the court with an
Okay.
agreed upon cap.
All right, so it is a plea bargain.
In that aspect, yes, sir.
Yes,
Okay.
yes,
All right, well then, I'm going to have to put him under oath and ask him some questions about the document.
yes, sir.
Mr. Hocutt, I'm going to place you under oath, but I'm only going to ask you questions about this document, okay? You can raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, sir. Mr. Hocutt, I'm holding in my hand this waiver of jury. Did you go over that with Mr. Weiner? And did you understand it? And I'm sure that he explained to you that both the United States Constitution and the Texas Constitution guarantee you in a felony case, a trial by jury. Do you understand that? And you couldn't be convicted of any offense unless and until a jury found you guilty beyond a reasonable doubt. Do you understand that? And no one can take that right to a jury trial away from you. I can't, your attorney can't, and the state can't. Do you understand that? The only person that can waive that right is you. And you believe like, do you feel like you understand what's going on in here? And is this what you want to do? And if for some reason this plea bargain falls through or your deal with the state goes away, then you could still have a right to a trial, or can't talk today, you'd still have a right to a trial, but it would be by the court and not a jury. Do you understand that?
Yes, sir.
And you still want to do this? And Mr. Weiner, do you believe that he's executed this waiver knowingly, intelligently, and voluntarily?
Yes, Your Honor. I've represented Mr. Hocutt almost 2 years now. I believe he understands exactly what he's doing today.
When the court finds that he has, the court also notes that the state has consented and the court has approved it. This is the 3rd day of June, 2021. And when are we resetting him? July 8th?
That's fine with me.
That's good with us. Yes, sir.
Okay, that's when I have it reset. All right, Mr. Hocutt, I'm going to reset you for July 8th at 1:30. And that's for a plea. So we'll see you then.
Great, appreciate it. Thanks, Barry.
Judge, that's all I have today. Maybe excused.
Yes, sir.
Thank you.
Justin Daniel should be the same page, Judge.
Justin Daniel. All right, this is cause number CR 18-0747-392, the state of Texas versus Justin Daniel, and that is set for status.
Yes, Your Honor, we have an agreement with the state. It does involve a protective order being put together. It's my understanding the state needs a little bit of time. I was told that next week would probably be enough time.
It's a 3-year-old case.
It is. I am going to be in the court. Hopefully Kevin doesn't get mad at me, but on the 9th next week. if we could put him back on the 9th, hopefully we could maybe enter into that plea bargain that day.
July 9th, 1:30, or June 9th, sorry, June 9th,
Yes, sir.
1:30. All right, Mr. Daniel, well, you're the one on bond. You all right with that? All right, we'll see you June 9th, 1:30 for a plea.
And then I've got one other. I'm going to circle back around though. Okay?
Sure.
Thank you, Judge.
Mr. Stevens. Or Mr. Giat, sorry.
Judge, I can, mine will be quick.
Okay.
He's on Zoom. Kevin Garcia.
Kevin Garcia. Mr. Garcia, are you with us?
Yes, sir. I'm with you guys. Do you hear me?
I can hear you, but I can't see you.
You see me now?
That's what he did last time, Judge.
Right. Well, and then I know I told him last time that he was supposed to be in court today, but he's not in court.
There's a long list of Texas going back and forth, this one and the misdemeanor. The misdemeanor is set for June 10th. And he got confused.
Your Honor?
Yes, sir.
Yeah, I was confused. I thought the court date was on June 10th. I got the messages. I was prepared to go be there on June 10th, but I forget that there's two different court dates. And like, it's not that I forget, it's just so much to handle. Like I'm out on 2 bonds, so I have to call 2 bonds offices. And like, I don't know. It's so much and it's a big headache. And I've been trying so much to stay on task and trying to be there on time and everything, but I'll be there on the 10th for sure. But today,
10th is a misdemeanor, Mr.
I
Garcia.
didn't know today was court day today.
Well,
'Cause
I
it's
did.
two
Your
different
attorney
court
did.
dates.
Hold
And
on. You know
we
what the
did it.
maximum effective range of an excuse is, Mr. Garcia?
Your Honor, I'm
0
sorry.
meters. 0 meters. That's the maximum effective range of an excuse. But you're at least appearing via Zoom. Did he? What time is the one on the 10th?
I think it's 8:30, Judge.
Your Honor, I live like 4 hours away, Your Honor.
Well, you're going to be here on the 10th, so get ready for a long day. What time?
Judge, I will tell you this, my wife is being scheduled for surgery. We're trying to get a neurosurgeon and a back surgeon and a general surgeon. They're doing it not the surgery this week, they're scheduling it all with Mother Francis. So when they tell us we've got 24 hours to be there, when they can get all 3 of them together. Judge Perry. I don't know. I never know what she starts at 8:30. Y'all can just slide on over to 1 o'clock.
So we have court at 9? All right, then I'm going to
June
reset
10th.
him. June 10th, 9 o'clock. Mr. Garcia, what date are you set?
June 10th and apparently 9 o'clock.
No, not apparently. What date are you set, Mr. Garcia?
June 10th, 9 o'clock, Your Honor.
There you go. So I will see you in person in the courtroom along with Mr. Giat hopefully on June 10th at 9 a.m.
I'll let y'all
All
know.
right, Your
one
Honor,
way
I'll
or
be
the
there
other.
on time.
Well, he needs to be here even
He'll
if you're
need to
not.
be here, but
I'll be there on time, Your Honor.
All righty.
be at my office at 8.
Yes, sir.
And
I'm
gonna
sorry,
recall
Your
it.
Honor, and I'm sorry, Ms. Paul.
That's all right, Judge Memphis.
Yes, sir. Thank you. All right, you can log off now, Mr. Garcia.
I'll call you.
Mr. Stevens. All right, this is cause number CR 20-0044-392, the state of Texas versus Gerald Henderson, set for status.
It is, Your Honor.
Yes, Your Honor, we gave a 10-year offer. However, Mr. Stevens came to me today with some information that he has asked that the state look into regarding some previous information on the complaining witness. So
July 8th, 1:30 for status. Mr. Henderson, you're the one in jail. You're all right with that?
Yes, sir.
All right, I'm resetting your case, July 8th, 1:30 for status.
And then George Smith, Your Honor.
George Smith. We haven't moved the case yet. George Smith.
Judge, Mr. Smith had his times confused. He thought court was at 9 this morning, so he didn't have a ride, so he walked about 4 miles to my office, got there at 10 after 9. My secretary said, it's at 1:30. He said, I may have to walk to get there. She said, well, whatever, it said at 1:30. And I can't reach him now.
You can walk from Gun Barrel about 10 to 1:30.
I told him I'd pick him up on the side of the road if I saw him. But I didn't see him.
All right, it's cause number CR 19-0767-392, the state of Texas versus George Smith. George Smith's not in the lobby. Is there a George Smith in the courtroom? I see no one. I hear no answer. There's not a George Smith appearing via Zoom. The time is now 2:07. Court was at 1:30, or the docket was set for 1:30. The court will entertain a motion.
Thank you, Judge. State request bond for attorney's costs.
Granted, case is issued, he'll be held with no bond. Now, I did just drive from Gun Barrel because I went there for lunch and I didn't see anybody on the side of the road. I did see a guy in Gun Barrel. I don't know what he looks like, but he'll never make it if he was just starting when I saw it.
Well, he walked from Legendary to my office, and then he walked after that from my office across the big Lake Bridge to somebody's house for a ride. That's the last we've heard from him.
I didn't see him.
All right, Judge. Might be excused.
Yes, sir. Mr. Mills.
I have Robert Sloan.
All right, this is cause number CR 19-0391-392, the state of Texas versus Roderick Sloan, and this is set for jury trial announcement for the jury trial on June 21st at 8:30.
We're ready.
All right, what number is he? Ooh, okay, good chance. All right, Mr. Sloan, then both sides have announced ready. So after now, there will be no plea bargains. You'll get a trial unless y'all get something worked out by June 21st. And so does he have an offer?
It was a probation. What was offered exactly? It was a probation
Two
offer.
offers, one was for felony probation or misdemeanor jail time.
His second degree felony?
That's correct.
And so I'm sure he understands that if he is convicted by a jury, that the punishment range would be 2 to 20 and up to a $10,000 fine.
Yes, and if we can prove he's not probation eligible, he may get probation.
Can I see the indictment? Oh, the last date to plea is the 16th. I'm sorry. Y'all have a Brooks notice? Okay. All right, either way. All right, Mr. Sloan, so I mean, I presume you're innocent, and I'm not trying to get you to plead one way or the other, but if you do have a trial and the jury finds you guilty beyond a reasonable doubt, and if the state proves you're not probation eligible, then it'll be 2 to 20. You understand that? All righty, sir. We'll see you on what day?
8:30 to 21st.
All right, June 21st at 8:30
Thank you.
here.
Hang on,
I talked to Judge Moore. It was his idea. Yeah.
ready for my next one?
Mhm.
Ricardo Abundis.
Ricardo Abundis. All right. If we can get Norma to swear in. You solemnly swear that you will translate from English to Spanish and Spanish to English to the best of your ability. Thank you, ma'am. This is cause number CR 21-0423-392, the state of Texas versus Ricardo Abundis. That is set for arraignment. Mr. Mills.
Your Honor, I've been over the indictment with Mr. Abundis. His name is spelled correctly. We'll waive the formal reading of the indictment and plead not guilty for arraignment.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates in writing.
And Judge, if we, you want to get a date as soon as we can get one. So this is actually a re-indictment.
Right, I
of an
see
old
that.
Case, and I believe we have a plea agreement worked out, but the state still needs to do some victim notification. And so we were going to ask the court to maybe set that for a plea, maybe next week or something like that. Next week. I'm here Tuesday, Wednesday, and Thursday. I know I'm not young.
All right, Mr. Abundez, I'm going to reset your case by request for June 10th at 9 o'clock for a plea. Okay, sir?
Thank you.
Okay.
And Your Honor, just to be clear, we do have to talk to victims like Mr. Mills said, so I just wanted to make sure.
Okay, so you may not be a plea.
I think it's gonna be a plea, but we do have to talk to victims before we move forward.
Understood. So let's keep it on June 10th, figure out what happens then.
Yes, Your Honor. Thank
Thank
you.
you. Thank you. And that's all I have. May I be excused?
Yes, sir.
Thank you.
Your Honor, may I be excused?
Yes, ma'am. Thank you. Mr. Scott. Oh, did you have any more, Mr. Mills? Sorry.
Oh, that's it.
Okay, yep. Sorry, Mr. Scott, come on.
Casey Presswood, Your Honor, for arraignment on today.
He also apparently has a warrant, Your Honor. Or cases.
All right, these are cause numbers CR 21-0348 and 0349-392, both styled the state of Texas versus Casey Presswood, and both set for arraignment. Mr. Scott.
Yes, Your Honor, I've got both indictments. His name is spelled correctly. I've gone over the indictments. He understands what he's charged with. We'll waive formal reading of the indictments, enter plea of not guilty to both.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your 2 next court dates are August the 4th at 9 a.m. for discovery status, and then again on September 1st at 9 a.m. for pretrial. Can I see the docket sheet? Thank you.
Oh, they're together. They're at the same time. Yeah. We'll have to come back to different dates. Yeah, that's. We're close family.
Mr. Scott, he's on a personal bond, and apparently he was set for arraignment previously. His name was called. He wasn't here. And that's why I issued the capious with no bond.
Well, I show on one indictment, he's got a $1,500 PR bond. On the other indictment for the PCS, $4,500, and it doesn't show to be a PR bond.
First indictment was for the bond that was called on. The other one was an arrest.
Before or after I set the no bond? So he's bonded out from the jail after I set a no bond?
Yeah, you may remember I told you that Mr. Preston wanted to come in on Friday. We were in a contested hearing. I told him that wasn't possible. He came anyway via Uber. And when he came into the building, he was arrested on that.
But they still let him bond out on a no bond.
That was the warrant was issued at the time.
Oh,
It was like-
Okay. Well, it seems to me like we have a lot of these personal bonds. You know, they're not indicted within 90 days, and so they're entitled to a PR bond. They get out, and then they're their own bondsman. It's kind of the way I look at it. It's their responsibility to keep their address right. We send the notice to the address because they are their own bondsman. And then they don't show up.
The first indictment, he had a bond.
Right.
The second indictment, Judge Calhoun, when he set bonds, made it into a $1,500 personal bond. So he.
So he never filled out the paperwork.
No, the paperwork.
I got you. Okay, fair enough. All right, then what I'm gonna do is, I'm gonna reinstate his bond to, what was the first one?
First indictment.
4,500 on the first. indictment.
$4,500 surety bond on, is that 0348?
Yes, sir.
And then the
He's got a PR bond, but there's no bond on that.
okay. All right, so I've reinstated the bond on the first one, and the second one is, it remains at $1,500 personal bond. And so, Mr. Presswood, your next two court dates, did I tell him that already?
Yes, sir. We've got them in writing, Your Honor.
All right, so we will see you back here on August the 4th at 9 a.m.
No problem. I'll be here.
All right.
Thank you, Judge.
Thank you, Your Honor.
You're welcome. And I'm recalling the capias on that for the record. Oh, hold on. Mr. Scott, tell him to come back in here. I forgot. I forgot to tell him. Mr. No, it's all right. I told you to go. It's, what was his name again? Presswood. Mr. Presswood, I'm going to order you to take a drug test based upon the nature of your charge. You'll go with probation, take the test. When you get done, come back in the courtroom. Don't leave, and we'll go over the results together. Okay, sir? All right. I'm glad you reminded me. I forgot about that. Mr. Stevens.
Brandon Zachary for a plate.
Right. I got another one I can call. I think my body's sworn. We can call.
It's all right. You can do it right there. Just takes a second.
Oh,
It's court reporter a break. Y'all. Be right back.
just for off the record or just clarification.
We're off the record.
We don't have to stop you two. Last time he did not appear, we had presented some documentation that he was at the hospital. I think you read it and it said heartburn. He ultimately got admitted and was in there for 3 days. That information was then sent to the court. I think you had stated if you got some more documentation, you take it under advisement, but he was actually admitted for 3 days.
For heartburn?
He has scarring in his lungs and
Okay.
he can explain it.
That's fine. As long as he has a doctor's excuse, that's fine.
We'll withdraw that one.
Right, then on this court, we'll recall it. Mr. Presswood.
Gotta hit myself. Should have called another case.
No, you're all right. These artificial breaks are good. Ready? All right, it's cause number CR 18-0729-392, the state of Texas versus Brandon Zachary. And this was set today for jury trial announcement. However, a plea has been presented on the 0729 case. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Zachary,
We're ready.
sir, is your name Brandon Reed Zachary?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of credit or debit card abuse?
Yes, sir.
I get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Zachary, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Zachary, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is. Mr. Zachary, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir, it's not necessary.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony, which carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And plea bargain state?
Thank you, Judge. The agreement was a 4-year deferred probation in this case. With a $400 fine, attorney's fees, court costs, $34.62 restitution to Mid-South Bank, $180 restitution to DPS Tyler, and as a condition of the probation, the defendants pay AA and $50 to Crime Stopper. Your analysis testing, obtain GED within 24 months, 240 hours of community service, drug offender program, and complete a substance abuse evaluation and all the recommendations. And the state will ask the court to take into consideration CR 20-0620-392 and an unfiled possession control system.
And it doesn't have the $180 lab fee check. Want me to check it?
That was on the, it should have been on the.
No objection to checking it, Your Honor. That is part of the agreement.
All right, since there is restitution to Mid-South Bank, I'll just write DPS lab underneath this one.
Thank you, Judge.
All right, is that your understanding of the plea bargain, Mr. Zachary?
Yes, sir.
Is that your understanding, Mr. Stevens?
It is, Your Honor. However, he had some concerns about the community service hours. He's on disability because of his heart condition. I advised him to present that documentation to the probation office, and I think they can accommodate him on those situations. And he brought a whole packet of pills and it's all right there.
Y'all work it out with probation. I mean,
And that's what I told him.
people either need to do community service hours, and I think now we waive them if they work a full-time job. Isn't that a sad state in our nation that they don't do community service, they'll work a job? Try to go to Cat and D's today, they don't even have enough people working there.
That is our understanding, Your Honor, the agreement.
All right. Well, Mr. Zachary, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back and sign it with Mr. Stevens?
Yes, sir.
Do you have any questions about it?
No, sir.
Next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over that document with Mr. Stevens?
Yes, sir.
And did you sign that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Stevens?
No, sir.
If you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to that state jail felony offense as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence.
Thank you, Judge. State offers in the evidence states exhibit number 1. exhibit number 2. States 1 is the offense report and states 2 is more discovery.
Objection.
Admitted.
Nothing further, resting.
Rest closed as well.
All right, then, Mr. Zachary, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defers making any finding of guilt, places you on 4 years community supervision. You do have credit. Well, no, he doesn't have any credit. Is that true?
I think there's a few days of credit,
I don't have any on the plea papers.
2 months of credit.
We need to get that credit and then we'll get it in, but you will get credit for any time that you've already served on this sentence. Orders you to pay your fine, attorney's fees, court costs, and the restitution to DPS as well as Mid-South Bank, and abide by all the regular and special terms and conditions of community supervision. In punishing you on this case, the court has considered CR 20-0620-392 and an unindicted PCS from an offense date of June 9th of 2019. And Mr. Zachary, have you ever been on probation before?
Yes, sir.
Did you successfully complete it?
Yes, sir.
You know what can happen to you if you don't successfully complete this probation?
Yes, sir.
What can happen?
2 years,
Do you know how state jail time is served?
day for day.
Day for day, that's right. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest. You'd be brought back before the court, and if at a hearing, the court found if the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 2 years in state jail. Do you understand that?
Yes, sir.
Good luck to you, sir. You need to see probation before you leave.
We'll have Scott McDowell.
Did he have a fever?
62 days out.
He did? But he's here?
No.
Scott McDowell. All right, cause number CR 19-0314-392, the state of Texas versus Scott McDowell. Is there a Scott McDowell in the courtroom? I see no one. I hear no answer. There's not a Scott McDowell appearing via Zoom. No answer in the lobby. I know that he contacted the court and stated that he had been exposed to COVID and had a fever. And I believe that the coordinator told him he needed some kind of medical proof of that, and that they would take his temperature when he got here and not let him in, but apparently he's not.
And for the record, he had contacted our office, claimed he did go to the hospital, that they gave him Tylenol to reduce his fever, and told him to then go to a clinic to get a COVID test done. None of that, we obviously said any documentation needs to be sent to my office. As of now, we haven't received any information. My office tried to call him just recently a couple of times to try to get him to appear via Zoom, so he could at least explain to the court what he's doing, where he's at. And now his phone's going to voicemail and we cannot get hold of him.
What was the plea for?
3 years.
3 years.
3 years TDC.
I'm pretty sure he could have had a COVID test at the hospital too.
Right, they don't send you away. I think they give you one. All right, well then, the court will entertain a motion.
We're going to request a bond forfeiture, Judge.
All right, time is now 2:28. Docket was set for 1:30. Granted a KPSO issue, he'll be held with no bond. Now, if you can give me medical proof that he's whatever, I'll reconsider.
Judge, I think this goes without saying, but unless, of course, Mr. Stevens can provide some sort of medical documentation, the state's offer is off the table.
Okay. Maybe he's watching on YouTube. All right.
Well, his phone's dead.
May I be?
Yes, sir.
Thank you.
Okay.
On top of page 4.
Holmes, come on up. All right, this is cause number CR 20-0327-392, the state of Texas versus Justin Combs. This is set today for status. However, a plea has been presented to the court. Is the state ready?
We're ready, Your Honor.
And on behalf of Mr. Combs,
We're present, ready, Your Honor.
sir, is your name Justin Scott Combs?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the first-degree felony offense of murder?
Yes, sir.
I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Combs, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain, you can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Combs, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, sir.
And Mr. Harrington, do you believe your client is competent?
I do, Your Honor. I believe he's competent.
And the court finds that he is competent. Mr. Combs, I know that we arranged you sometime back on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
Yes, sir.
But you understand the charge.
Yes, sir.
Well, as originally indicted, that charge is a first-degree felony. A first-degree felony carries a punishment range of not less than 5 years or more than 99 years or life in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment? However, it's my understanding that you and your attorney have this deal worked out with the state where they'd recommend that the court convict you of a lesser included offense of that which is charged in the indictment of manslaughter. Manslaughter is a second degree felony, and that carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand both those ranges of punishment
Yes, sir.
in the plea bargain?
Your Honor, it's 15 years confinement in TDC with a plea of true to the deadly weapon allegation. He's going to get credit for his back time. He's also responsible for attorney's fees and court costs.
Is that your understanding of the plea bargain, Mr. Combs?
Yes, sir.
Is that your understanding, Mr. Harrington?
It is, Your Honor.
Mr. Combs, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document and sign them?
Yes, sir.
Do you have any questions about it? The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Harrington?
Yes, sir.
And did you sign that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Harrington? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to the lesser included offense, the second degree felony offense of manslaughter? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Sure.
I'll hear the evidence.
Your Honor, he also needs to enter a plea of true.
Well, I was looking at it. It's not included within your,
Is there not deadly weapon notice in the file?
that's what I was looking for in your indictment. Because murder in and of itself is a 3G offense.
Right.
Manslaughter, I don't think is. Am I right? Anybody?
I could get the court a written notice of deadly weapon allegation. The court preferred, but that was part of the agreement.
No, I understand, but I don't think manslaughter is in and of itself. Is it a 3G?
No, it's not.
I don't think
Deadly
so.
weapon.
So you wouldn't have had to have one because murder already was. I tell you what we're gonna have to do. If I'm gonna take his plea on it, we're gonna have to present it to him and then let him plead to it.
Sure, I can type that up real quick.
Okay, so let's do this. What I'm gonna do is I'm gonna recess at this point in time, and then we'll reconvene with the rest of the plea bargain.
Yes.
You can have a seat, Mr. Jones. Sorry,
Can I get that cause number? I'm sorry.
CR 20-0327-392. And I'll just set that to the side. Let's have a seat, Mr. Combs. We've got to do another bit of paperwork. Mr. Head.
Page 3, Jeremy Jackson for discovery status.
All right, this is cause number CR 20-0650-392, the state of Texas versus Jeremy Jackson, set for discovery status. Where are we at?
Your Honor, I do believe we received everything. We just recently received some audio and video information. So I do believe we have everything now.
Okay. Anything outstanding that you know of, state? And is there an offer?
There is, the current offer is $5.
Okay. All right, well then, Mr. Jackson, the court deems discovery status is held. Your next court date is July 8th at 1:30 for pretrial. So as soon as you receive that reset notice, you can have a seat, sir.
And then, Your Honor, on page 2, Walter Caffey for a plea.
Walter Caffey. Those are for me. I'm just keeping them up here. So I don't need you to take it. You're gonna take it? Okay. Yeah, just keep it there. He's gonna come back. Did I already call it? No, this is cause number CR 21-0042-392, the state of Texas versus Walter Nichols Caffey. This was set for pretrial today. However, a plea has been presented to the court. Is the state ready? And on behalf of Mr. Caffey,
We're ready, Your Honor.
all right, sir, is your name Walter Nichols Caffey?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance?
Yes, sir.
I get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Caffey, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Sure.
And Mr. Caffey, have you ever been treated for any mental health or emotional issues?
No.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Head, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is. Mr. Caffey, I know you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? I'm sorry?
No, thank you.
All right, well, but do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony, which carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand the range of punishments in the plea bargain?
Yes, Your Honor. In exchange for a plea of guilty to the state jail possession of controlled substance, the plea recommendation is 2 years deferred probation with 14 days credit as of today, $650 in attorney's fees, court costs, restitution of $180 to DPS, regular conditions of probation, and special conditions of probation to be AA or NA meetings, $50 to Crime Stoppers, urinalysis testing, obtain a GED within 24 months, 200 hours of community service at 10 hours a month, and complete the substance abuse evaluation and follow the recommended treatment.
Is that your understanding of the plea bargain, Mr. Caffey?
Yes, Your Honor.
Is that your understanding, Mr. Head?
It is, Your Honor.
And Mr. Caffey, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Head?
Yes, I did.
And did you sign it?
Yes, sir.
Do you have any questions about it? The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign the second page?
Yes, sir.
Do you have any questions about it? Do you have any questions about any of the documents you read and went over with Mr. Head? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain? You want to enter into the plea bargain?
I guess so.
You guess or you do?
Yeah. Yeah.
Okay, well then I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance as alleged in the indictment? Are you pleading guilty because you are guilty and for no other reason? I hear the evidence.
Your Honor, we offer States Exhibit 1, the offense report, States Exhibit 2, the lab report, and Exhibit 3, the inventory discovery report.
No objection.
1 through 3 are admitted.
And Your Honor, I don't believe that indicated we're taking into consideration an unindicted continuous violence, family violence case, and the victim has been notified.
Okay,
State rests in peace.
Mr. Head.
John, we'd rest in close. No additional evidence.
All right, then, Mr. Caffey, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defers making any finding, places you on 2 years community supervision, orders you to pay your attorney's fees, court costs, and lab fee, and to abide by all the regular and special terms and conditions of community supervision. And is also in punishing you on this case, the court has considered the unindicted continuous violence case. And let's see, Mr. Caffey, have you ever been on probation before?
No, sir.
Well, there's lots of things you have to do and a few things you can't do while you're on probation. Do you know what can happen to you if you violate any of this probation? What can happen?
You reckon here?
Well, I'll explain a little further. Here's what can happen. If you violate even one term of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be brought back before the court. If at a hearing, the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 2 years in state jail. Do you understand it? And do you know how state jail time is served? Do you know how state jail time is served? Generally day for day. Do you understand that? All right, sir. Good luck to you. You need to see probation before you leave.
Here.
Is this the first time? I'll be able to now. If he's not going to go. Man, let me just hold on to it. Let me finish this one up. Just hold off for right now.
Your Honor, I can step back and let.
Okay.
I filed a copy of that, but well, that is the original copy that I filed with the clerk and Mr. Harrington seen it.
So the manner means it's his hands. Okay. I mean, I guess that could work. All right, Mr. Combs, come on back up. Let's go back on the record in cause number CR 20-0327-392, the state of Texas versus Justin Scott Combs. Mr. Combs, just a few minutes ago, you entered a plea of guilty to the second-degree felony offense of manslaughter, which was a lesser included of that which is charged in the indictment. Are you still entering into that plea?
Yes.
Then I'll ask you further, sir. Is it true or not true that during the commission of that offense that you did then and there use or exhibit a deadly weapon, your hands? Is that true or not true? And are you pleading true because it is true and for no other reason?
Yes.
I'll hear the evidence.
Judge, I have stage 1, offense report. Stage 2 is Michael Morton compliance. Stage 3 is a supplementary offense report, and stage 4 is supplementary Michael Morton compliance. Objection.
All are admitted. And the victim's family?
Your Honor, they're understanding and accepting of this agreement that we entered into with Mr. Combs and his attorney, and they wish to proceed with this plea bargain as well.
Okay. And are they going to provide any victim impact
They
statements?
requested that Ms. Palmer and myself, that's still the agreement? Yes.
Okay.
They requested that Ms. Palmer and myself read them to the court.
All right, well, then we'll handle those here in just a few minutes. State rest and close.
Yes, sir.
Mr. Harrington?
Rest in close.
All right, then, Mr. Combs, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that second-degree felony offense of manslaughter, a lesser included of that which is alleged in the indictment. The court also, based upon your plea of true and the evidence, finds it's true that you did use or exhibit a deadly weapon during the commission of the offense. The court follows the plea bargain, sentences you to 15 years in the Texas Department of Criminal Justice. You do have credit of 436 days as of today. And the court orders you to pay your attorney's fees and court costs. And Mr. Combs, a few more things to go over with you. Did you get an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
And finally, sir, now that you have been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. Those are legal terms. So if you have any questions, consult with an attorney. And you're now remanded back to the custody of the Henderson County Sheriff for transport to the appropriate authorities to serve out your sentence, but not yet. And before you go, you will need to see the bailiff. Am I forgetting something?
Did the court make an affirmative finding on the deadly weapon?
I think I just did. The court has enough evidence to find it true and does find it
Okay.
true. Did I find it true? Let Melanie look real quick. After I pronounce sentence. Okay, I did. All right, and does the state wish to present the victim impact statements in?
Yes, Your Honor.
All right, Mr. Combs, if you'll turn around, please.
This victim impact statement is by Stephanie R. Thomas, the first sister of the victim. To this date, I've had a hard time processing how and why this is my reality. Am I really writing this right now? I pray every night that this dizzy dream isn't reality. However, every morning, nearly a year and a half later, I still wake up disoriented from this lifetime of the nightmare. Corinthians 13:4-8 was one of my sister's favorite quotes from the Bible, and probably the only quote she lived upon within her short 36 years of life. Unfortunately, Corinthians 13:8, love never failed. This part failed her. Your love failed her. Your love for your addictions outweighed and failed my sister and y'all's son, her purpose in life, her only reason for living her last hellish year of life. Not only did your love for your addictions rob you of maybe a maximum of 15 years of your life, your addictions robbed my nephew of the person that loved him most in this cruel world and the life he deserved. Robbed a mother and a father of their firstborn, sisters of their first true best friend, nieces that will never know the love of man, including the confusion and hurt from family and friends that loves her. However, most importantly, your addictions rob my sister of her life. While you wake up with breath in your lungs, guilt on your heart, and 4 cement walls around you for hopefully the next 15 years, I hope that you make the best of Christy's love. The same love that had never failed you, nor your addictions, but only her own life. I hope that you make the best of it for her purpose in life, her only son.
This victim impact statement is by Jessica Thomas, second sister of the victim. I'm the youngest sister of the victim, Christy Combs. I have known Justin for 20 years, and I do believe the 15-year sentence by far is not fair. He took away a sister, a mother, a daughter, and an aunt, and my 4 daughters. How easy you got off. You get to breathe, think, you get to walk, you talk to your family and friends, and even your son. While Christy will never get to experience any of that. You don't know why you choose to do what you do, but you do believe justice will be served. May each and every day be another reminder that your addiction and selfishness, not only one person, will ruin the lives of many family members and friends.
Last victim impact statement is by Mrs. Thomas, the mother of Christy Combs. Justin, your actions caused Christy to get the death penalty, and you got at the most 15 years, which you will possibly serve 7.5. Do you really think that's fair? You said she was the love of your life, Lobster, but that's not true. Alcohol and drugs are your true love, because if she was, the first time you saw what you had done to her while you were messed up, you would have done everything within your power not to do it again. Instead, you ran back to drugs and alcohol and did it again and again. And so losing her was the worst thing I have ever experienced in my life. It's put a hole in my heart that will never heal. I miss her so much. I miss her phone calls, the way she would say, "Hi, Mama," "I love you, Mama," and sing happy birthday to me. I love the way she could sing. If it wasn't for my grandson, I almost wish she never met you at the bus stop that rainy day. You know that my grandson told us a few months after she died that he asked God every night to send her back to me. And now, almost a year and a half later, he calls her Christy. When I said it's Mama, he said, "No, it's Christy." I said, "She is your mama, and she will always be your mama," and he just laughed. I told him, "You and her will always be his parents," and he said, "No, Nana and Ricky are now my parents. They are raising me." You know how much it would hurt her if she was here. He was all she ever wanted and lived for. I know you didn't intend for this to happen, and you would do anything in this world to take it back if you could, but we have to deal with this now. I ask one thing from you, Justin. Please get help, not only for the addictions, but for these factual abuse issues too. My sister and I broke it in our family with us. Then you started it again. Maybe if you get help, we can stop it again before Jackson learns his behavior. I forgive you for the pain and the hurt and everything you have caused me through your actions that resulted in her death. I hope and pray that you find Jesus so that you can have his love and forgiveness and see Christy again and get her forgiveness. Jesus loves you, Justin, and he's waiting for you to open your heart and just believe in him and ask for forgiveness of your sins. Justin, you've been in our family for forever, for over 20 years. And I love you just like you were my own son. And she was my firstborn, and now she's gone forever. And I'm hurt, and I'm very, very angry.
Thank you, Ms. Palmer. Mr. Cox. Mr. Combs, you're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, sir. You need to see Mr. Halbert before you have a seat. Who was Mr. Presswood's attorney? I'll handle Mr. Head. He's right there. Mr. Head, come on up.
Your Honor, Christopher Farrell on page 3 has 2 cases set for pleas.
Okay. Mr. Harrington already did. That's fine. I don't need him. All right, these are cause number CR 19-0439 and CR 20-0577-392, both styled the state of Texas versus Christy Farrell. Excuse me, and both set for a plea today. Is the state ready?
State's ready, Your Honor.
And on behalf of Ms. Farrell,
We're ready, Your Honor.
is she not sworn? I'm sorry? Is this them? Oh, sorry. I thought those were the ones I just gave you. Go ahead, sorry. All right, ma'am, is your name Christy Lynn Farrell? And are you the same person that was originally indicted by a Henderson County grand jury in this 439 case for the felony offense of unauthorized use of a vehicle? And get you to raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. And you can lower your hand. Ms. Farrell, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Ms. Farrell, have you ever been treated for any mental health or emotional issues? Do you understand what's going on here? And Mr. Head, do you believe your client is competent?
I do, Your Honor.
And the court finds that she is competent. Ms. Farrell, I know you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But do you understand the charge? Well, originally, that charge is a state jail felony, which carries a punishment range of not less than 180 days nor more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range of punishment? However, if the court finds the first and second enhancement paragraphs true in the indictment, then the punishment range would be not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment in the plea bargain?
Thank you, Judge. The agreement was for 2 years TBC on that state jail enhanced. State would ask this court to take this consideration. CR 20-0577-392. And she also has to pay her attorney's fees, court costs, and she has credit for 180 days.
That your understanding of the plea bargain, Ms. Farrell? Is that your understanding, Mr. Head?
It is.
Did you need to talk to her real quick? That's okay. Just making sure I get the right. All right. And so that's everybody's understanding of the plea bargain?
Your Honor, we may need to step back then. I thought we had talked about it. We were on the same page about the credits, but she just, I think she misunderstood where we were on the time credit. So if we could step back and we'll straighten that up.
Okay. It's all right. And let's see, Mr. Presswood, come on up. Can I see the docket sheet? No, I thought that was still Combs. I didn't think you'd taken it yet. I didn't see you swap it out. He's not taking one before. Okay. All right, this is back on the record in cause numbers CR 21-0348 and 0349-392. Both style, the state of Texas versus Casey Presswood. Mr. Presswood was ordered to take a drug test today. Apparently, he has not gone, but has admitted that yesterday he smoked weed and took Ritalin. Not quite sure that's how you spell that, but and I guess I don't have a prescription. So here's what I'm going to do, Mr. Presswood. Everybody gets their one free shot in here with me. So I'm going to place you on conditions of bond, no alcohol, no drugs not prescribed, no illegal drugs, and no THC or marijuana. I don't care if you go to Colorado.
Yes, Your Honor.
None of that stuff. And so you're going to receive those in writing. Once you receive those written bond conditions in writing with my signature on them, you're free to go, and I'll see you back on your reset date.
Yes, Your Honor.
However, when you come in here again in
No
July,
excuses? Right, I've got you. I've got one for you too, on that, how far excuses.
whenever you're done, just let me know and I'll finish.
Yeah,
You done?
I'm done.
Okay, so if you come back in here the next time, I'm gonna drug test you again. And if you test positive, are you high right now?
I'm gonna give you a.
Nah, I don't need the joke.
Sorry. ADHD, I'm just like.
It's okay.
Very misunderstood.
If you test positive the next time, you may go out that door and not that one. If you need help, get it. There's lots of help out there. Thank you,
Yes, Your
sir. See you in July.
Thank you, Your Honor.
He still needs to wait for his signed bond conditions.
Oh. Wanted to tell you a joke, Judge.
I kind of want to hear it, but it's probably not the right format.
No.
Form. He can tell it to me when he comes back and drug test me. You got anything else?
I have a plea, Your Honor.
Okay. Are we?
Shamar Willis.
I have Christy Farrell. Are we done with Miss Farrell yet?
We can finish it real quick.
That's the new one. So, sorry, Mr. Scott, since I'm in the middle of this one, let me finish it. So it looks like there is 282.
Ms. Farrell is correct.
Okay. So I am going to write on the plea form 282. All right, let's go back on the record and cause number CR 19-0439-392, the state of Texas versus Christy Lynn Farrell. We had recessed the plea for check time credit, and I have been presented with a new judgment with the time credit of 282 days.
That's correct.
And I've also annotated that on the, or changed from 182 to 282 on the plea recommendation sheet. And so Ms. Farrell, I did put that on there. So Ms. Farrell, with the change of the 282 days credit towards your sentence, is that your understanding of the plea bargain? Mr. Head, is that your understanding?
It is, Your Honor.
Ms. Farrell, a few minutes ago, you told me you could read and write the English language. I'm going to show you two documents. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Head? And did you sign the front and the back? Do you have any questions about that document? The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document? Did you sign the second page? Any questions about it? Do you have any questions about any of the documents you read and went over with Mr. Head? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case? Do you want to waive your right to a jury trial and enter into this plea bargain?
Yes.
Then I'll ask you, ma'am, how do you plead to that felony offense of unauthorized use of a vehicle, as alleged in the indictment? Guilty or not guilty? And then further, Ms. Farrell, are you pleading guilty because you are guilty and for no other reason? All right, and then further, is it true or not true that in January of 2006 in the 7th District Court of Smith County, Texas, you were finally convicted of the state jail felony offense of unauthorized use of a motor vehicle? Is that true or not true? That's true.
Oh, yeah. Yes.
Is it true?
Yes.
All right. And are you pleading true because it is true and for no other reason? All right. And then finally, is it true or not true that also in the 7th District Court of Smith County in October of 2015, you were convicted of the state jail felony of credit or debit card abuse? Is that true or not true?
Yes, sir. Yes. Oh, true.
And are you pleading true because it is true for no other reason?
Yes.
I'll hear the evidence.
Thank you, Judge. State offers in the evidence, states 1 and states 2. States 1 is the offense report, states 2 is Martin's complaint.
No objection, Your Honor.
Rest in peace.
Admitted. And Mr. Head?
Rest in close, Your Honor.
All right, Ms. Farrell, based upon your guilty plea in the evidence, the court has enough evidence to find you guilty and does find you guilty of the felony offense of unauthorized use of a vehicle. And based upon your pleas of true to the enhancement paragraphs as well as the evidence, the court has enough evidence to find them true and does find them true. The court will follow the plea bargain, sentences you to 2 years in the Texas Department of Criminal Justice with credit for 282 days as of today, and orders you to pay your attorney's fees and court costs. And in sentencing you, the court has considered the indicted case of CR 20-0577-392. Just a couple more things to go over with you, Ms. Farrell. Have you seen the new judgment? Do you want to look at those dates there? Go ahead and look at it. Make sure she sees where we've changed the days, because I don't think she's seen that copy.
Okay.
All right, and now that you've had an opportunity to review the updated version of that, is your name, the charge, and the time credit correct? All right, man. Finally, based upon this final conviction, you are now under Texas law ineligible to possess a firearm or ammunition. Those are legal terms, so if you have any questions, consult with an attorney. You're now remanded back to the custody of the Henderson County Sheriff for transport to the appropriate authorities to serve out your sentence. Good luck. You need to see Mr. Halbert to your right before you sit down. Yes, sir.
Your Honor, the last case I have is Mr. Yarbrough set for a plea on page.
I got you. Right here. Let's go to it.
And Your Honor, if we could kind of sidebar just very briefly, the state's attorney and I just to kind of bring you up to
Sure.
one thing off of that.
So do we still not need to arraign him?
Your Honor, I have reviewed a copy of the indictment.
Let me call it now. I'll let you put that on the record. This is CR 21-0422-173, the state of Texas versus Kobe Blaine Yarborough. Set today for a plea. Is the state ready?
It's ready.
And on behalf of Mr. Yarborough.
Your Honor, we're ready.
Okay, and then as far as the arraignment,
Your Honor, if I could see the copy of the, just to show Mr. Yarborough. Appears correctly, doesn't it? Spelled correctly. Your Honor, Mr. Yarborough's name does appear correctly. He understands the nature of these charges. We've gone over these previously. Based on the fact that we do believe we have a plea offer today, we are anticipating a plea of guilty to a lesser included under
count two, is that
under
correct?
count two, yes, sir.
Okay. All right, well then I'll just do this for purposes of arraignment. I'll enter a plea of not guilty, and then we'll move on to the plea bargain. And so we'll adjourn the arraignment, and then as far as, and I'll just call it again, that way we bookmark it. CR 21-0422-173, the state of Texas versus Kobe Blaine Yarborough, set for a plea as a state ready. And on behalf of Mr. Yarborough.
We're ready, Your Honor.
All right, sir, is your name Kobe Blaine Yarborough?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury in count two of this indictment for the second-degree felony offense of indecency with a child?
Yes, sir.
If I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Yarborough, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
Mr. Yarborough, have you ever been treated for any mental health or emotional issues?
Yes, sir.
And do you understand what's going on in here today? Mr. Head, do you believe your client is competent?
Your Honor, I do believe he's confident. I would just tell the court that when this case started off in the juvenile court, he had undergone a psychological evaluation. And as a part of that, he was diagnosed with ADHD and with a mood disorder. But I do believe he's confident. All right, I don't believe there's any question about that.
All right, and then Mr. Yarborough, you do understand what's going on in here, right?
Yes, sir.
Well, earlier you told me you hadn't been. Did you not understand my question?
I guess not, sir.
Okay, but you understand what's going on,
Sir,
and you went over this paper with Mr. Head, and did you understand what he explained to you?
yes, sir.
All right, well, Mr. Yarborough, based upon your statements, your answers to my questions, your demeanor here in court, as well as the statements of your attorney, I'm going to find you are competent. Mr. Yarborough, we just arraigned you just a few minutes ago in another hearing. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
Yes, sir.
But do you understand the charge?
I do.
Well, as indicted in count two of that indictment, as charged in count two of that indictment, that is a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that punishment range?
Yes, sir.
However, it's my understanding that you have this deal worked out with the state whereby they would recommend that the court that the court place you on community supervision and defer a finding on a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment? And I didn't tell you, but that third-degree felony would be on a lesser included charge. Do you understand that? In the plea bargain in the case?
Your Honor, the state recommends 7 years deferred adjudication on the lesser included third-degree felony of indecency with child by exposure to include 1 day credit as of today's date, as well as $1,400 in attorney's fees, $455 in court costs, standard conditions to include child advocacy center fee, crime stoppers fee, drug testing, GED within 24 months, 600 hours of community service, sex offender program and conditions, substance abuse evaluation, no contact with the victim, compliance with the lifetime protective order that has been agreed to in this case, and Mr. Yarborough would be required to register as a sex offender after his.
All right, Mr. Yarborough, is that your understanding of the plea bargain?
Yes, sir.
Is that your understanding, Mr. Head?
It is, Your Honor.
Mr. Yarborough, a few minutes ago, you told me you could read and write the English language.
Yes, sir.
I'm going to go over two documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that with Mr. Head?
Yes, sir.
And did you sign the front and the back?
I did.
You have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign the second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you read and went over with Mr. Head?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to the lesser included offense of indecency with a child by exposure of that which is charged in count 2 of that indictment, a third-degree felony? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason? I'll hear the evidence.
The state offers Exhibit 1, a copy of the offense report, Exhibit 2, the Henderson County Juvenile Case Submission Form, and Exhibit 3, a copy of the defendant's written statement.
No objection.
Admitted.
And Your Honor, I did just want to make it clear for purposes of the record that we are asking the court to consider count 1 of the indictment.
Okay.
And also that we normally would submit to the court the initial inventory report. However, because this was a juvenile case, we don't have that. We have shared all of our discovery with Mr. Head.
Okay. And then as far as the complaining witnesses,
They are on board and present here today.
okay, I saw some folks leave. I don't know, were those the complaining witnesses?
Yes, Your Honor, and her mother is here.
But they're still on board with the plea bargain, is that correct?
Yes, Your Honor.
Okay. All right. Anything else from the state?
State rest and close.
All right, Mr. Head?
Rest in closure.
All right, Mr. Yarborough, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty of that lesser included third-degree felony offense. However, the court will follow the plea bargain, defers making any finding of guilt, places you on 7 years community supervision. The court is considering count 1 of that same indictment and sentencing you. You do have 1 day credit as any credit you may eventually have to serve. Again, places you on 7 years community supervision, orders you to pay your attorney's fees, court costs, and abide by all the regular and special terms and conditions of community supervision. And Mr. Yarborough, as young as you are, I still need to ask you though, have you ever been on probation?
Yes, sir.
Well, there are a lot of things you have to do and a few things you can't do on probation. You understand that?
Yes, sir.
And do you know what can happen to you if you violate any term or condition of this community supervision?
Yes, sir.
What can happen?
Arrest.
And let me explain it to you in case I see you again. We won't have to go over it. Here's what can happen. If you violate even 1 term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest. You'd be brought back before this court. If at a hearing, the court found it were true that you violated even 1 term or condition, the court could find you guilty, revoke your probation, and sentence you up to 10 years in prison. Do you understand that? So would you agree with me? It's extremely important you abide by these terms and conditions.
Yes, sir.
I hope you do, sir. Good luck to you. You need to see probation before you leave. And do y'all, let's go off the record.
I'm sorry.
He needs to stay here. If he's never been arrested, doesn't he have to book in, book out?
I believe they did that as a juvenile, but if not,
It's I understand the correlation, but.
Well, on an indictment, you can issue a summons rather than, there is a provision to issue a summons rather than a case. And so
It's normally, even if they plea, it's a non-arrest, we have to go to the jail.
Well, the only reason that is because of the reporting
Yeah,
on
it's
sieges.
The TRN reporting is for, it's important.
Y'all figure it out, and if we need to, that's where that's where it And who is it that's going to be providing it to the court?
Natasha Marie. Mother of
All right, Ms. Williams. Whenever you're ready, ma'am.
Wilson, Kobe's aunt, the victim's mother. I just wanted to tell you that. We love you. And we hope that during this time, you're the best person that you can, that we know you to be. We want his parents to know that we love you guys. It's been very hard for our family, very impactful, but God loves you, and God gives grace, and that's what we're here to do with that.
Thank you, ma'am. Thank you. You see probation before you go.
Your Honor, that's all I have, man.
Yes, sir. Thank you. Oh, and for the record, I'll recall the capias. So we only have two left. Is that correct? Shamar Willis and Jason Baxter.
Mr. Wonder, I was taking your chambers.
So let's handle, John Scott's ready, so let's handle his case.
Thank you, Judge.
Really wasn't planning on taking a break, but if y'all need to, then
We're gonna have questions we'd like to answer before you.
sure. All right, this is cause number CR 20-0681-392, the state of Texas versus Shamar Willis. And that is set today for status. However, a plea has been presented to the court. Is the state ready? And on behalf of Mr. Willis?
Ready, Your Honor.
All right, sir, is your name Shamar Allen Willis?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the third-degree felony offense of assault family violence?
Yes, sir.
And get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Now you can lower your hand. Mr. Willis, can you read and write the English language? Are you a U.S. citizen? You have to speak up just a little bit. She's got to
Yes, sir.
hear you. If it turns out you're not, then you enter into this plea bargain. It can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Willis, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here? Mr. Scott, do you believe the client's competent?
I do, Your Honor.
The court finds that he is competent. Mr. Willis, I know you were already arraigned on this case. However, would you like the prosecutor to read the indictment out loud in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
And the plea bargain?
Yes, Your Honor. In exchange for a plea of guilty as indicted, the state's recommendation is to defer adjudication of guilt and place him on 5 years probation, to consider 2 misdemeanors, one possession of marijuana off at state 918 of 20, and a misdemeanor unlawful restraint of 412 of 20, with 1 day credit as of today, $500 fine, $750 attorney's fees, $305 court costs, regular conditions of probation, and special conditions of probation, including $50 to Crime Stoppers, your analysis testing, obtain a GED within 24 months, 200 hours of community service at 10 hours a month, attend a victim impact panel within 90 days, complete a substance abuse evaluation, follow recommended treatment, attend an anger management class, and do not have contact with Emily Moreno, including restitution of $6,803 to Emily Moreno.
Is that your understanding of the plea bargain, Mr. Willis?
Yes, sir.
Is that your understanding, Mr. Scott?
It is, Your Honor.
Mr. Willis, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you, sir. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that with Mr. Scott?
Yes, sir, I
And
did.
did you sign the front and the back?
Yes, sir, I
Do you
did.
have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document, Mr. Scott?
Yes, sir, I did.
And did you sign the second page?
Yes, sir, I did.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Scott?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that third-degree felony offense of assault, family violence as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Your Honor, state author states exhibit 1, the offense report, states exhibit 2, which is the inventory discovery report, and the victim is in agreement with this recommendation.
No,
I'm sorry,
no objection.
Admitted.
state rests and closes. Your Honor.
Defendant rest and closure.
All right, then, Mr. Willis, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making any finding, follows the plea bargain, considers in sentencing you or punishing you these two unfiled misdemeanors. The court places you on community supervision for 5 years. You do have 1 day credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, and court costs, as well as that restitution, and to abide by all the regular and special terms and conditions of community supervision. Mr. Willis, have you ever been on probation before?
When I was a teenager.
Did you successfully complete it?
Yes, sir.
So you know what it takes.
Yes, sir.
You know what can happen to you if you violate this community supervision?
Yes, sir.
What can happen?
I can be indicted on any form of.
Actually, you've already been indicted. Here's what can happen. You're not entitled to a jury trial or a trial anymore.
Yes, sir.
So here's what can happen. If you violate any term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest. You'd be brought back before the court. If at a hearing, the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 10 years in prison. You understand?
Yes, sir.
So would you agree with me? It's extremely important you abide by these terms and conditions.
Yes, sir.
I hope you do, sir. Good luck to you. You need to see probation before you leave. Yes, sir.
Maybe excuse John.
Yes, sir. Appreciate you.
Yes, sir. Thank you.
Ms. Vandiver, thank you. I'm glad you reminded me of that. Who is her attorney? Is Mr. Green still? Oh, there he is, right there. Is she just, can I see the docket sheet? I'm sorry? All right, it's back on the record in cause number CR 20-0570-392, the state of Texas versus Jennifer Vandiver. Ms. Vandiver was ordered to take a drug test today, and apparently she's tested positive for methamphetamine, THC, and opiates. And see, it looks like she tested positive back in December of 2020, and the court placed her on conditions of bond. And so I know there's a PTI, but again, this is kind of like yesterday. Unless there's one right there, I got to treat her like I do everybody else.
No, this one's a little different than yesterday. That one had been accepted. This one's still pending.
Okay.
So this one, she's still on conditions with this one.
Okay.
Judge, for the purposes of limited purposes of this hearing, I'd like Ms. Vandiver, she would like to explain to you what's happened and ask that her sample be sent to lab for confirmation.
Okay, do I need to put her under oath for the limited purpose of this?
I think she needs to be under oath.
All right, ma'am, you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand, Mr. Green.
Judge, if state didn't object, I'd ask Ms. Vandiver just to tell you the narrative, and Mr. Strong be more than
Sure.
welcome to cross-examine her if he wants to.
Okay.
I've had to go and stay somewhere where my ex does it all the time in a small RV because I lost my job in March. And I turned around and got COVID and the flu. So the only place I was left to stay was my ex's. So he does do it all the time. In a small RV, there's not much I can do about it. The opiate, the one thing on there's Tylenol 3. I have a prescription for that. I do have some places to go to find them.
I mean, I've heard that before, where people are in cars and, I mean, I don't know. Here's what I'm gonna do. Ms. Vandiver, I'm going to send it off for confirmation. You need to provide that prescription to the opiate, for the positive opiate test, to probation. So we'll send it off for confirmation and we'll deal with it when you get back.
How do I get it to them?
Oh, we already have it.
No, I'm.
So the
talking about-
prescription?
Yeah. Just bring it to me.
Bring it. I don't know, there's all kinds of ways. Take a picture of it and email it.
Bring it back.
Fax it. And so I'm gonna give you the benefit of the doubt, but I'm gonna send it off for confirmation. All righty. We'll see you.
Judge, I know for a long time that, the standard was you couldn't test positive for secondhand. And then all of a sudden, we're having, indictments for child endangerment for 6-month-old kids or 8-month-old kids that have.
Yeah, but that's for methamphetamine. I don't know if I've seen them for THC because it's all over the place. So I don't know. I see your point, but I mean,
Those are hair follicles.
I lived in a motor home for a year while I was building my house, and I know how close. That's probably why I don't want to say I'm buying her story, but I'm seeing maybe a possibility there. But the meth and the opiates, another. We'll send those off for confirmation.
I understand blood in urine has a shorter half-life than hair follicles.
We'll make progress towards, the state's offer, and maybe we can get everything resolved. I'll be out all next week, but I'll be back on the 14th.
Okay. All right. You free to go, Ms. Vandiver.
Yes.
I guess I'm gonna have to take a recess because I'm trying to get to Houston. Oh, is she? What were we doing with
And
her?
she's the one that called me and Mr. Inslee and let her know that she did have car trouble. I was under the impression she was coming from Dallas. She actually lives in Round Rock. That's why it took her as long as it's taken her.
So she's here?
She's here, right there. And I was looking through the clerk's files, gonna see if there was a possible resolution that we could reach today, but if the court needs somewhere to go, then I understand.
Well,
If the court would entertain us a lot, having more time to get a resolution on it.
Can I see the docket sheet? I need the docket sheet. Ms. Goff, come on up. This is CR 20-0447-392. State of Texas versus Holly Goff. So she already took a UA and was negative.
Yes, sir. She's also on electronic monitoring as a condition of her release under parole. So she is being supervised through parole as well.
All right, well, it's set for status. Where are we at?
Did you go over the scope?
I have, and you made an offer, there was either a probation or a time or a state jail time. And I was in the process of trying to calculate how much jail time she has. That we might be interested in doing something for a time if she has an occurred.
Sure. Okay. Before Ms. Colts had the case, I did have a case I did too.
Well, Ms. Goff, I've looked on the docket sheet. We had trouble getting you once before, and then you're late. I appreciate the fact that you drove from Round Rock, but two things you don't want to be late for, your wedding and felony court. And so I'm going to withdraw the capias. I'm just going to reset status. That's all right with y'all to July 8th at 1:30.
That's fine. Judge.
And she's already tested negative, so I'm not going to drug test her again. But I may next time. So just know that. And so, Ms. Goff, once you receive your reset notice, unless your attorney needs you to hang around for a minute, you're free to go. But it is noted on the docket sheet that you were late. So if you're late the next time, I can't promise I'll recall any capias.
Yes, sir. That's why I started trying to call as soon as.
No, I appreciate that people that try, things happen, but. All right, well, I guess I'm gonna take a break to talk to, you need anything?
I don't, Judge. That's all my business.
Yes,
I
sir.
was just gonna look at the court file.
Before we go on, so I can't find it. Here it is. Mr. Baxter, come on up, sir. We're gonna handle you before Smith County gets you back and doesn't let us have you back.
I know, right?
I know, trust me. All right. This is cause number CR 18-0131-173, the state of Texas versus Jason Elick Baxter. And this is set today on a motion to proceed. Is the state ready?
We are, Your Honor.
And on behalf of the defendant,
We're ready, Judge.
right, sir, is your name Jason Baxter?
Yes, sir, it is.
And are you the same person that was originally placed on probation out of this court back in August of 2018?
Yes, sir, I am.
If I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, it will be.
You can lower your hand. All right, Mr. Baxter, can you read and write the English language?
Yes, sir, I can.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand?
Yes, sir.
And Mr. Baxter, have you ever been treated for any mental health or emotional issue?
No, sir.
You understand what's going on in here today?
Yes, sir, I do.
And Mr. Weiner, do you believe your client is competent?
I do, Judge.
Court finds that he is. Mr. Baxter, have you been served with a copy of the state's motion to proceed in your case?
Yes, sir, I have.
And how long ago has that been? Let me ask you this, has it been more than 10 days?
Yes, it has.
And do you understand what it is that the state says you did or failed to do to violate your probation?
6 counts, I believe.
Yes, sir. And do you need the prosecutor to read those counts out loud?
No, sir, I'm aware of it.
But you understand them?
Yes, sir.
In the plea bargain?
Your Honor, it's 10 years confinement in TDC, credit for 502 days served, plus an outstanding balance on court costs, I believe it is.
And that's basically with his pleas of true, the deal would be that I would basically find him guilty of a lesser included
Right.
of deadly conduct and then sentence him to 10 years.
Yes, sir.
Okay, all right. Is that your understanding of the plea bargain, Mr. Baxter?
Yes, sir, it is.
Is that your understanding, Mr. Weiner?
Yes, Your Honor, it's not a 3G offense. The state's also filed a motion to abandon the deadly weapon from
Okay.
the underlying case. That's our understanding, Judge.
All right, and so that's everybody's understanding.
Yes.
All right, well, Mr. Baxter, you told me you could read and write the English language. I'm showing you this document, which is the agreed sentencing on one side. Did you see that?
Yes, sir.
Did you go over it with Mr. Weiner?
Yes, sir, and have signed it.
And you signed it. Do you have any questions about it?
No, sir.
On the back are certain admonishments and waivers concerning your motion to proceed. Did you go over that with him?
Yes, sir.
Do you have any questions about it?
No, sir, I don't.
Do you have any questions about any of the documents you read and went over with Mr. Weiner?
I just wanted for the record that the deadly weapon was abandoned on all this.
Well, I don't think they asserted, well, it was an ag assault. Was there a deadly weapon?
He was placed on probation for aggravated assault with a deadly weapon. And like I mentioned, the state has filed a motion to abandon the deadly weapon that
Okay.
the court will sign once it takes the
Yeah,
plea
and I
bargain.
don't know how it was indicted, but
Right.
I didn't know if there was a separate
There was
enhancement.
not. The deadly weapon was in the body of the indictment. There was no separate
Okay.
deadly weapon allegation.
So by my finding him guilty of the lesser included, there is no deadly weapon, but
Correct.
we'll sign it just to be safe.
Yes, sir. Thank you very
All right.
much.
And so, well, if you read and went over these with Mr. Weiner, Mr. Baxter, I know he explained to you that you have a statutory right to have a hearing in this case.
Yes, sir.
And if you were to have a hearing and the state were to prove at least one of these 6 counts true, you could do a lot better or a lot worse in this deal you have worked out. Do you want a hearing?
No, sir.
Do you want to waive your right to a hearing and continue with this plea bargain?
Yes, sir, I do.
All right, then I'll ask you, sir, how do you plead to counts 1 through 6 of the state's motion to proceed? Are those things true or not true?
True.
And are you pleading true because they are true and
Yes,
for no
sir.
other reason? I hear the evidence.
Judge of offer states 1, the defendant's plea of true and stipulation of evidence, which I believe is included in the court's file there.
It is, Judge. We've previously received, reviewed, and have signed states one, have no objection to it.
Admitted. Anything else?
No, Judge, rest in close.
Rest in close, Judge.
All right, then, Mr. Baxter, based upon your pleas of true and the evidence, the court has enough evidence to find counts 1 through 6 true, and the court does find them true. The court will follow the plea bargain, finds you guilty of the lesser included offense of that which was charged in the indictment, the 3rd-degree felony offense of deadly conduct, The court is abandoning, I don't think there is, but if there is granting the state's motion to abandon the deadly weapon. The court is not finding or not making a finding of a deadly weapon. The court follows the plea bargain, sentences you to 10 years in the Texas Department of Criminal Justice with credit for 502 days as of today, and orders you to pay your new and previous court costs. And a couple more things, Mr. Baxter, now that you've been finally convicted of this offense, you're now under Texas law ineligible to possess a firearm or ammunition. Those are legal terms, so if you have any questions about that, consult with an attorney.
Yes, sir.
And then, did you have an opportunity to review this judgment?
Looks good to me.
Was your name, the charge, and the time
Yes,
credit
sir.
correct? All right, sir, you're now remanded back to the custody of the sheriff so he can transfer you to Smith County and you can take care of your business
Thank you,
there.
Judge.
Good luck to you,
Yes,
sir.
sir.
Need to see Mr. Halbert before you go.
Thanks. Appreciate it. Yeah, yeah, yeah.
All right, let me get out of here.